Hello everyone, my name is Eva Ecker. I'm a PhD student at Ghent University, and today I will talk about the influence of institutional architecture of asylum institutions on international protection determination. I will elaborate my point through the cases of Belgium and the Netherlands, but before I do that, I will start with an introduction on what could possibly have an influence on refugee status determination.
First, we need to distinguish different refugee statuses that are granted by states as a protective tool against non-refoulement. Starting from the 50s, we see that both Belgium and the Netherlands used the Convention refugee status. This status provides a strong protection with many rights and is hard to revoke. Also, both countries started granting a temporary protection status for displaced persons from the beginning of the 90s. However, there were also differences between the countries. The Netherlands started expanding protection to non-convention refugees in 1974, which is way earlier than Belgium, which only introduced a non-convention refugee status in 1991. These non-convention statuses offered less protection, were easier to revoke, and there was more room for interpretation. While the motivation of the Netherlands to establish a de facto status was mainly the protection of diplomatic interests, in Belgium the motivation to establish a form of protection for non-convention refugees was to guarantee Article 3 of the European Convention on Human Rights. When we look at the Netherlands between 1974 and 1991, we see that the majority of recognitions happened to the de facto statuses and not through the convention refugee status. In Belgium, however, until 1991, there was only one refugee status, so all refugees were convention refugees. Even after the non-return clause was introduced, in 1991, the convention refugee status was still used way more often, as the non-return clause was only used exceptionally as a last resort. From 2004 onwards, the EU wanted to harmonize the protection statuses, resulting in a convention refugee status and a subsidiary protection status, both regulated by the European Qualification Directive. Both countries still have other humanitarian status. However, these humanitarian statuses are not linked to protection needs based on situation in the countries of origin, but on other compassionate grounds.
One can question why countries decide to provide a non-convention refugee status instead of expanding the scope of the Geneva Refugee Convention through a liberal interpretation of it. We can also question whether it is a good thing for refugee protection to provide non-convention refugee statuses, albeit de facto statuses, subsidiary protection or other forms of protection. We've tried to provide an answer to these questions through comparing Belgium and the Netherlands between 1975 and 1991, because that is a time frame where the Netherlands did have non-convention refugee statuses and Belgium did not have multiple protection statuses.
Did providing multiple protection statuses benefit refugee protection? Our first hypothesis says no. Through establishing multiple protection statuses, the Geneva Refugee Convention was hollowed out. Providing multiple legally weaker protection statuses thus enhanced a restrictive interpretation of the Refugee Convention. For the Dutch versus Belgium case, if this hypothesis turns out to be true, this would mean that Belgium had a better refugee status arsenal between 1974 and 1991, operating a liberal interpretation of the Geneva Refugee Convention. Our second hypothesis, however, says yes, through establishing multiple protection statuses, people who would otherwise not fall into the scope of the Geneva Convention at least get some protection, instead of no protection at all. For the Dutch and Belgium case, if this hypothesis turns out to be true, this would mean that the Netherlands had a better refugee status arsenal between 1974 and 1991, while Belgium operated a restrictive recognition policy.
We test our hypotheses through comparing the recognition rates of Belgium and the Netherlands between 1975 and 1991. We do so to find out whether wielding only one refugee status enhances a liberal or the opposite, a restrictive interpretation of the Geneva Refugee Convention. I will go back to our preliminary findings at the end of our video, but now I've explained to you what refugee statuses are circulating in Belgium and the Netherlands. I will focus a bit more on the recognition process itself.
So what elements determine whether one gets international protection? Well, first, there are the legal instruments that most of you are already familiar with. To name the most important ones, the Geneva Refugee Convention, the EU Qualification Directive and other European legislation, the European Convention on Human Rights,
national legislation, and national and European jurisdiction. Of course, all these legal instruments are not isolated from each other, but are all somewhat intertwined. So, those are some legal criteria, but is that all? Could it be that maybe there are other elements that have an influence on the asylum decision? Let's, for example, take a look at asylum institutions. Do they have an influence on the asylum decision? When we go back to the legal instruments above, we know that most of them promote harmonization of asylum and recognition policies in Europe, as was the case with the recognition statuses, which I mentioned earlier. Yet surprisingly, these instruments mention little about the institutional setup of asylum determination. This concerns the question, what kind of actors are or are not involved in the refugee status determination, in what way, and which steps of the asylum procedure? The few instruments that do suggest an institutional setup for asylum institutions are only of a recommendatory nature, thus forming an extra legal element. This means that member states are free to decide about the way they organize their asylum institutions. As a consequence of the extra-legal nature of the organization of asylum institutions, member states choose to organize their asylum institutions very differently, which is also the case for Belgium and the Netherlands. And those are two very interesting countries to compare because they have a similar way of organizing their asylum institutions in the past. In the 50s, it was UNHCR that decided in both countries to decide about the refugee status determination. While we look at today, we see that both countries organize their asylum institutions very differently. To easier understand the institutional setup of asylum decisions, let's first outline the steps in asylum procedure. If you want to be recognized as a refugee, first, you have to apply for asylum with a state authority. Second, the state will perform a first screening on your application, mainly filtering out applications on the basis of form-based or easily determined substantive criteria. Sometimes the application will not be rejected, but will be processed through an accelerated procedure. The third step is a substantive assessment on whether or not one is a refugee. For this assessment, the legal instruments I mentioned earlier are used. Finally, one can appeal a negative eligibility or protection decision. In this research, we will mainly focus on the third step, although sometimes the other steps can be relevant when there is a connection with the protection decision. Both the Dutch and Belgian institutional setup regarding asylum decisions have changed multiple times throughout time. I will elaborate on the most important changes. In the Netherlands first, it was the UNHCR that got the mandate from the Ministry of Foreign Affairs to grant the Convention refugee status. However, there was no appeal available. In 1975, the Ministry of Justice took over the recognition task of the UNHCR and installed an administrative appeal possibility in 1976. In 1982, an asylum department was installed within the Ministry of Justice that specifically focused on asylum cases. In 1994, a new asylum department within a newly established immigration office was created. Also, from then on, the appeal was handled by regular courts instead of the administrative courts. In Belgium, the UNHCR also got the mandate from the Ministry of Foreign Affairs to grant a convention refugee status, again without appeal. In 1998, an independent asylum office was established with an administrative appeal possibility. The asylum office was transferred to the Ministry of Internal Affairs in 1991, and in 2007 the appeal instance was reformed. As you can see, the Netherlands and Belgium have totally different institutional setup regarding the asylum decision. First, the competences fall under different ministries, the Ministry of Justice in the Netherlands and the Ministry of Internal Affairs in Belgium. Second, in the Netherlands, the police is responsible for the registration of asylum applications, while in Belgium this is done by the Immigration Office. Third, and foremost, when we look at the asylum institutions themselves, we observe two important things. First, in the Netherlands, the decision stays within the ministry itself. In Belgium, an independent administration was established outside the direct hierarchy of the ministry. In the Netherlands, the asylum decision is taken by the directorate within the Immigration Office. So you could say that the Immigration Office is the Asylum Office, while in Belgium, the Immigration Office and Asylum Office are entirely separated. So you could say that the Asylum Office is not the Immigration Office. Finally, we see that in the Netherlands, the appeal is covered by regular courts, while in Belgium, a specialized administrative court was established concerning alien and asylum legislation. So we just saw that Belgium and the Netherlands have very different asylum institutions. But the question here that's really important is, do these differences actually have an effect on the refugee status determination? Let's take a look again at our organization chart to illustrate our different hypotheses.
Does institutional architecture matter? Our first hypothesis says that institutional asylum architecture does matter, following a mindset that the Dutch Asylum Department is contaminated by immigration control or other interests, while the sole mission of the Belgian Asylum Office is to protect refugees. This hypothesis, however, follows the assumption that institutional independence means that there is also an organizational independence or an autonomy in practice. However, our second hypothesis, following a mindset of multiple organizational identities, says that the Dutch Asylum Department is just as dedicated as the Belgian Asylum Office is to protect refugees, as the staff of the department is shielded from the immigration control objectives of the Immigration Office and the Ministry.
We are testing our hypotheses through a qualitative historical analysis of the architecture of asylum offices. We specifically study the institutional setup and the changes that were made over time and the motivation behind choices that were made. We do this through literature research, archival research, and we are interviewing key players and witnesses in the field. While we are still in the middle of our research, I can already present to you some preliminary findings.
Our first research question is, did providing multiple protection statuses benefit refugee protection? First of all, it is hard to find comparable numbers relating nationality, time frame, and whether or not a distinction is made between first instance decisions and appeals. Also, there's not always data available for our protection statuses that are granted. Moreover, it is not always clear whether an asylum application is decided upon in the same year as it was lodged, which can also distort results. Taking account these limitations, we try to find an answer on our research question. A first example concerns the Iranian asylum seekers. When we look at the recognition numbers, we see that in Belgium, more refugees got a Geneva Convention status than in the Netherlands. These results indicate that our first hypothesis prevails, that more refugee statuses were detrimental for refugee protection. However, we still need to be cautious. For the Netherlands, we do not yet know for sure the percentages of people that got a de facto refugee status or got a protection status after appeal. For Belgium, the statistics are easier as there was no appeal available and there were no other protection statuses. Another example concerns the Sri Lankan asylum seekers. When we look at these numbers, we see that Sri Lankan people were more often protected if we include the de facto statuses and the statuses granted in appeal. Thus, in this case, it seems that our second hypothesis prevails, that more refugee statuses were beneficial for refugee protection. For now, we have to conclude that we need more numbers to make a stronger case. We also need to look into the role of several potentially impactful variables, such as the number of asylum cases and nationality. When we look at our second question, does institutional asylum architecture matter? We can also already share some insights. First, regarding the independence, when we look at autonomy, we see several interferences of politics throughout time in the Netherlands, while in Belgium, most results indicate a quite autonomous functioning of the Asylum Office. When we look closer to the staff, we see that the top management is politically appointed in both countries. However, when you look at the executive staff in the Netherlands, we see that while the permanent staff solely works for the asylum department, this is not the case for the temporary staff, which is partially staffed by people from the Return and Removal Office and by the Ministry of Foreign Affairs, which could also be a possible contamination source. During the crisis in Yugoslavia between 1992 and 1996, in the Netherlands, only temporary protection was offered to these people, thus wielding a restrictive interpretation of the Geneva Convention. While in Belgium, both temporary protection and convention refugee protection was given, thus wielding a liberal interpretation of the Geneva Convention. When we observe the relation between the first decision instances and the appeal instances, we see that in the Netherlands, the appeal instance interferes less and less with the asylum department decisions. However, there is literature that criticizes the appeal instances, claiming that they are reducing the right to international protection to the discretionary power of the state. In Belgium, at the moment, we can only say that the appeal instances interfere little in the decisions of the Asylum Office. Summarized, based on what we know now, When we look at the Netherlands, we can say that the Asylum Department is rather shielded from direct influence from the Immigration Office. However, we notice that some other actors do manage to get through the protective shield that protects refugee interests. When we look at Belgium, we can say that the shield mostly protects the refugee protection mission of the Asylum Office. However, there might be some possible contamination elements that we still need to investigate in depth.
As you can see, we've already made quite some progress, but we still have to figure some things out. We hope to provide more answers by the final PROTECT conference. Thank you for watching this video.